If you're on Twitter, then you've probably seen this video by self-described Israel advocate Natasha Hausdorff in your mentions.
There is a critical rule of customary international law that determines the borders of newly emerging states at their moment of independence. It is called Uti Possidetis Juris. It's applied universally wherever there is no agreement to the contrary. So it's the default rule. And in Israel's case, in 1948, it determined that the pre-existing administrative lines of the British mandate that preceded the State of Israel became Israel's international borders when it declared independence. This is the rule that the pre-existing administrative lines become the new lines, the new borders of the state. And the reason that it was introduced was to promote stability and certainty and to prevent fratricidal struggles. The International Court of Justice outlined these justifications for it when it recognized that it had become established. It was introduced in the 19th century, applied in South America with the withdrawal of the Spanish. It's applied in Asia and Africa, also to the dissolution of the former communist federations. Ukraine's borders followed Uti Possidetis Juris. And that's quite a critical comparison, because I think the three of us would agree that Russia has been in occupation of Crimea from Ukraine. Why is that? Because Crimea was part of Ukraine according to the rule of Uti Possidetis Juris at Ukraine's formation. Well, in the same way, when Israel came into existence, the West Bank and East Jerusalem and Gaza fell within that territory of the administrative lines of the pre-existing British mandate. Now, that's critical, because immediately in this war of annihilation that I've described, Jordan occupies the West Bank and East Jerusalem from Israel, and Egypt occupies Gaza. And that occupation ended in 1967 when Israel recovered that territory. That's when this allegation of occupation for many people is dated from. The problem with that is you cannot occupy what is already your own sovereign territory.
I.e., if Ukraine was to retake Crimea and hold it, no one would say that was occupation of Crimea.
From Russia,
yes.
Indeed.
In this video, part of a series of videos where I debunk what I call international Hasbara law, I will rely on actual international law to show you why this claim is BS. Let me start by briefly explaining what Uti Possidetis actually is in international law. Uti Possidetis was first used in the 19th century by the newly independent Latin American republics seeking to legitimize their claims to former Spanish colonial domains. The basic argument here is that the new independent republics would continue to possess, or Uti Possidetis in Latin, whichever lands the corresponding colonial entity that preceded them possessed. So the United Provinces of the River Plate, or in the Argentina, would possess the lands that the Viceroyalty of the River Plate had possessed. Same for Peru, Colombia, you get the gist of it. This was predictably a pretty terrible solution to indigenous peoples who did not get a right to self-determination or political emancipation after Latin American independence. Thus, while the Quechua people of Peru had risen up in arms in 1780 demanding equal rights, the Uti Possidetis rule of Latin independence left their now neo-colonial oppression as second-class citizens mostly intact. In other instances, like the Aymara or the Yanomami, Uti Possidetis meant that their lands and nations ended up split between two countries. Uti Possidetis only recognized colonial entities a right to possess sovereignty post-independence. If indigenous people rebelled, they were not allowed to claim possession over the land they owned pre-Spanish colonization. Take the Mapuche in the southern tip of South America, for instance. They were never colonized by the Spanish. Instead, as of the 1860s, they were colonized by the newly created Chilean Republic. When they rebelled against Chile in 1881, no one believed that they had a right to secede and continue to possess the Chilean province of Angol, created to colonize Mapuche territory through Uti Possidetis. On the contrary, only Chile had that right. Indigenous groups seeking to break the territorial continuity and establish their own states were not accepted. This is a bit of a detour, but I believe strongly in the importance of not excluding indigenous people from the history of their own oppression and colonization. Now, what Hausdorff is doing in that viral video is applying Uti Possidetis to make the frankly preposterous claim that Israel is not really unlawfully occupying Palestine, as the International Court of Justice says, but that rather the West Bank, East Jerusalem, and Gaza can't be occupied because they always belonged to Israel through Uti Possidetis. I discussed this further during my fact-checking of her parliamentary testimony if you're interested in digging into that claim a little bit more.
Intervene here, Natasha. Do you agree then that the occupations are not legal?
She doesn't believe that the occupation
is not legal. Yes or no?
No, it's not a yes or no, because one cannot annex what is one's own sovereign territory. So the term annexation is misplaced here. Likewise, the term occupation, because when Israel recovered that territory, let me give you a parallel example, which I know members of the committee will be familiar with. Russia has occupied Crimea from Ukraine. Why? Because Ukraine's borders were settled by Uti Possidetis Juris. If Ukraine were to recover Crimea from Russia, in the same way that Israel recovered the West Bank, Judea and Samaria, and East Jerusalem from Jordan.
That's assuming that Israel owns that piece of land to start off with.
Well, yes, but I'm saying the same rules have to apply.
Can I come on to a
Otherwise,
different question, Natasha?
may I just finish the answer?
And I've got a different
the
question.
same rules have to apply.
This is, to say the least, a complete and deliberate misapplication of the principle. To fully debunk Hausdorff's claim, though, I need to address the actual source of the claim. You didn't seriously think Hausdorff came up with that all by herself, did you? No, Hausdorff is merely repeating an old argument initially advanced by George Mason professor and West Bank settler Eugene Kontorovich. And in full disclosure, to be clear, Eugene does not like me and has specifically called me an idiot for calling the West Bank, the land where the illegal settlement where he lives is built, well, the West Bank. He doesn't like it when I use that name. Anyway, in 2016, Kontorovich wrote an article alongside Abraham Bell, a professor at Bar Ilan University in Israel, entitled Palestine, Uti Possidetis Juris, and the Borders of Israel. The article's key passage reads as follows, quote, "It is clear that the relevant administrative borders of Palestine at the time of Israel's independence were the boundaries of the mandate as they had been set in 1923. Israel was the only state that emerged from mandatory Palestine, and it was the state whose identity matched the contemplated Jewish homeland required of the mandate and that fulfilled a legal Jewish claim to self-determination in the mandatory territories." End quote. The key word here is identity. Bell and Kontorovich are aware of the foundational flaw in their argument. Even the racist, white supremacist 19th century Latin Americans who came up with the Uti Possidetis rule did not consider it to apply only for the purposes of white self-determination. They were clear that when the Viceroyalty of Peru transformed into the Republic of Peru, that meant that all the people living in it, including its exoticized and oppressed indigenous majority, would cease to be Spanish subjects and would become Peruvian citizens. This is not Bell and Kontorovich's, or Hausdorff's for that matter, intention when they say Israel has an Uti Possidetis right to all of historic Palestine, particularly the West Bank, East Jerusalem, and Gaza, where Palestinians are not Israeli citizens. Israel must have a Jewish identity, and so they are very careful to justify denying this right of self-determination to Palestinians. The mandate itself, Bell and Kontorovich say, quote, "gives no indication of there being another entitled nation, describing only a Jewish national home and no other national home or national expression." End quote. They go on to explain how apparently this was normal in all mandates. The mandate of Iraq, for instance, never recognized Kurdish self-determination and things of the sort. But there is, of course, one key difference. Iraqi Kurds are Iraqi. They have a right to self-determination as Iraqis of Kurdish origin. In contrast, Bell and Kontorovich construct a reality where only the Jewish population of mandatory Palestine had a right to self-determination and no one else. This is why the whole Uti Possidetis argument fails from the get-go. When the Jewish Agency for Palestine, the representative of Jewish communities in mandatory Palestine, declared the independence of Israel, it was not declaring the independence of the people of Palestine, Jewish and Arab alike. No. They made it very clear, to the point of putting it in all caps in Israel's Declaration of Independence, that the state they were declaring was a Jewish one for Jews only.
זוהי זכותו הטבעית של העם היהודי להיות ככל עם ועם עומד ברשות עצמו במדינתו הריבונית אשר תפתח לרווחה את שערי המולדת לכל יהודי ותעניק לעם היהודי מעמד של אומה שוות זכויות בתוך העמים. לפיכך נתכנסנו אנו חברי מועצת העם, נציגי היישוב העברי והתנועה הציונית, ביום סיום המנדט הבריטי על ארץ ישראל. ותוקף זכותנו הטבעית וההיסטורית ועל יסוד החלטת עצרת האומות המאוחדות אנו מכריזים בזאת על הקמת מדינה יהודית בארץ ישראל, היא מדינת ישראל.
In the official English translation, they say, Accordingly, we, members of the People's Council, representatives of the Jewish community of Eretz Israel and of the Zionist movement, are here assembled on the day of the termination of the British mandate over Eretz Israel. And by virtue of our natural and historic right, and on the strength of the resolution of the United Nations General Assembly, hereby declare the establishment of a Jewish state in Eretz Israel, to be known as the State of Israel. This was not Mandatory Palestine's Declaration of Independence, but the independence of a Jewish state in Palestine, a different entity altogether from Palestine. This, therefore, puts Uti Possidetis completely outside of the reach of this new state. Israel is not Palestine. Palestine, instead, is the Arab-majority nation from which its Jewish minority community sought to escape. They were not fighting for the capital P people of Palestine. They were trying to declare themselves independent from it. This is why James Crawford, one of the most well-respected experts in the law of state creation, argues that Israel was born as a result of secession from Palestine, not as Palestine now independent. Indeed, he argues this is the only way in which Israel's history can make sense, contrary to common claims that Israel was created through the Jewish community's acceptance of the UN partition plan, a claim Hausdorff and Kontorovich must reject in favor of Uti Possidetis, by the way. This would be legally impossible. The partition plan was never implemented, and the territory of the plan's Jewish state is much smaller than Israel's current borders, meaning large chunks of Israel's territory would be unlawful annexation. No, Crawford says, that does not make sense. Secession, in turn, makes perfect sense. Israel seceded from Palestine and is currently claiming the right to control the territory it managed to secede from Palestine. No illegal annexation problem here. Plus, it also explains why the so-called peace process is necessary. Israel, as the seceded state, requires ultimate sign-off from Palestine, the host state, to consolidate its borders. But this means, of course, that contrary to the Uti Possidetis theory, Israel has no right to the West Bank, East Jerusalem, and Gaza. And why does secession make more sense than Uti Possidetis as well? Well, think about it. If Israel has an Uti Possidetis right to the pre-independence borders of Palestine, then it is currently subjecting millions of Palestinians in the West Bank, East Jerusalem, and Gaza not just to occupation, but statelessness and military rule. The way in which Kontorovich, Bell, and Hausdorff apply Uti Possidetis to Israel makes it an even more awful and cruel apartheid state than it already is for the Palestinian population under its control. Israel cannot claim an Uti Possidetis right to the mandate of Palestine precisely because it did not claim independence for Palestine. Hell, it didn't even grant civil rights to the Palestinian population it did not manage to ethnically cleanse in 1948. Upon its independence in 1948, Israel, this supposed only liberal democracy in the Middle East, subjected its Palestinian population to military rule within its own borders until 1966. Yes, I'm not even talking about occupied Palestinians in the West Bank. No, Palestinian citizens of Israel in Israeli territory were not subject to equal rights from the get-go, but treated like an enemy population within the borders of the state. Not even the racist white supremacists of 19th century Latin America did this to their indigenous population, who were named citizens from the very start. This is why, to this day, Palestinian citizens of Israel have less rights than Jewish citizens of Israel. Their property is regularly considered absentee, expropriated, and given to Israeli Jewish citizens instead. So the idea that Israel had the right identity to declare independence only for Israeli Jews, but at the same time had the right to all areas of the mandate, is frankly bizarre and racist. It simply does not treat Palestinians as equal human beings to Jewish Israelis. Now, of course, Hausdorff and Kontorovich rationalized their erasure of Palestinians on the Balfour Declaration's commitment to the establishment of a Jewish national home in Palestine. But again, this national home was to be built in Palestine. In fact, as far as the British were concerned, this national home had already been established by 1939, and efforts to transform an Arab-majority state into a Jewish-only one were not in line with the British government's policy in Palestine. So, in essence, what happened is that this national home declared independence from the mandate of Palestine and as such had no right or access to the Uti Possidetis rule. It is simply not the continuation of a colonial entity, but the secession of a part of it. Now, I'll be honest, the Uti Possidetis crowd were never taken seriously by the broader academic community. Most academics with an expertise on this matter treated Kontorovich and Bell's article with indifference at best and as a radical outlier at worst. In fact, for such an explosive claim, there are very, very few other scholars that have even bothered to engage with it. To my knowledge, the only one to address Kontorovich and Bell's claim was EJIL Zemach, senior lecturer at Ono Academic College in 2019. He called their argument, quote, unpersuasive. I'm leaving a link to the article in the video description below. After Zemach, engagement with Kontorovich's unpersuasive Uti Possidetis thesis went back to zero. The only instance I could find of someone actually invoking it was a cringy comment by one back then completely unknown Natasha Hausdorff in the comment section of a 2020 blog post by international law giant Joseph Weiler and Michael Saliternik at EJIL Talk, a well-respected legal blog, where they opposed Israel's purported annexation of the West Bank. After that, the Uti Possidetis discussion went back to irrelevance. That is, of course, until early 2024, when that very same Natasha Hausdorff dug it out of the hole it was in for the purposes of delegitimizing an at the time upcoming ICJ advisory opinion on whether Israel's presence in Palestine was unlawful. Hausdorff's contribution to the argument was to repackage it as an anti-Semitic double standard. Everyone else gets to apply Uti Possidetis, but not Israel. Israel is accused of being an occupier instead. Must be anti-Semitism.
But the application of this term occupation it's another blood libel, because it has no basis in international law. It is used as a political term. And the preface to it, this illegal occupation, which is so often referred to, is also only ever applied to Israel. There is no concept of a broader concept of illegal occupation in international law. And in all the instances, situations of real occupation, in the context of which is envisaged by the Geneva Conventions, and the context of the real transfer of populations in Cambodia, Vietnam, in Nagorno-Karabakh, in northern Cyprus, none of these cases has this allegation of illegal occupation or illegal settlements even been advanced. So this is another example of a modern blood libel being deployed against Israel in order to shape the discussion, in order to shape the international politics and diplomacy, in order then to put pressure on Israel. And we've seen the consequences of that, I'm afraid, in so many respects. This is what led to the 7th of October.
Her international Hasbara law views were relatively successful. When the ICJ issued its advisory opinion in July 2024, she managed to get 1 out of 15 judges, Judge Julia Sebutinde, to embrace the Uti Possidetis line. Not the most impressive tally, but for an unpersuasive and obscure argument originally made by an obviously biased West Bank settler, hey, it's something. For a brief The Hague minute, Sebutinde's dissent catapulted the Uti Possidetis line to the forefront of academic discourse. And it was obliterated. David Kretzmer, emeritus professor at Hebrew University, said the argument faced an, quote, insuperable obstacle: the fact that Israel is not the same as the mandate of Palestine. Andre de Hooch, professor of international law at the University of Groningen, called it a spurious argument, chastising Judge Sebutinde's censoring of the court's majority opinion, when rather it is the failings in her own dissent that, quote, should perhaps lead her to take a long, hard look in the mirror. Ouch. Sebutinde would go on to reveal that the reason why she embraced this argument was because God was counting on her to stand on the side of Israel. I'm not kidding, she really did say this. So, solid credentials, I guess, if God says so. But perhaps the best way to close the discussion on this is the fact that way back in 1996, before this whole discussion started, before Kontorovich or Hausdorff or Sebutinde ever even mentioned the words Uti Possidetis in relation to Israel, Malcolm Shaw, who would eventually literally represent Israel in its case against South Africa at the ICJ, and who Zionists themselves love to describe as the lawyer who wrote the book on international law, sometimes saying it to Natasha Hausdorff herself,
Israel is represented literally by the lawyer who wrote the book on international law,
wrote an article on the contemporary status of the Uti Possidetis principle, using the creation of Israel as an example of a situation where the principle of Uti Possidetis was not invoked in the, quote, interest of peace and security. Faced with irreconcilable differences and outbreaks of violence between the Jewish and Arab communities, Shaw says, the General Assembly chose partition over Uti Possidetis. So there you have it. Israel's own lawyer says Hausdorff is wrong. The claim that Israel has an Uti Possidetis right to the whole of Palestinian territory is bad Hasbara. Do not fall for it. Thanks for watching, and don't forget to like and subscribe. You can find my sources down below, and please let me know in the comments if you have any ideas for future videos. Until next time.